Well, hello there. Thanks for joining me. I am Dr. Jen, and I am so pleased that you've joined me for today's show. Today, we're exploring the location-specific tenancy guidelines for the Canadian province, Nova Scotia. In all of my location-specific episodes, I've included a bunch of hyperlinks to that location's landlord tenant law code, etc. In this case, the Nova Scotia Residential Tenancy Act. Each of my location specific podcasts is set up in the same way, answering the same four questions. One, what are the basics of that location's tenancy laws? Two, what are the nuances of that location? What's different? What stands out? Three, so what's some guidance about abandoned items left behind by a tenant in Nova Scotia? And four, where to get help in your local area if you have rentals in Nova Scotia. As I answer these questions, you'll see me screen share all kinds of documents specific to that location, as well as check off items on my bingo card to see what each location has, what they don't, and what is different. Over the many years I've been doing these episodes and traveling, I've created a bingo card of standard items I see most often in tenancy laws in different locations. At the very end of the episode, I'll go through that bingo card to help you figure out what you need to research more, especially if you have questions. I must tell you that there are more guiding documents than what I'm giving you here today. This is not everything. And even if I get it 100% right at the time of recording, laws can and will change even 5 minutes later. So you've got to do your own research, and maybe you need to be a licensed landlord. I don't know what it applies in your location, but you need to learn that. This is not all inclusive. You must research further in your specific area, but today's episode is designed to get you started. Okay, let me screen share right now so that you can see some of the hyperlinks that we've got going on. Here we go. Residential Tenancies Act of Nova Scotia. Here we go. Well, what we're looking for here's it's 52 pages, which is not a long not very long for a law. Oh, it's in like microprint though. Let me try to zoom in here a bit. So if you're watching this on YouTube at My Life as a Landlord, this is ideal so that you can see what is going on. I will try to talk through it as well if you're only listening, which is fine. But make sure that if you are serious about your Nova Scotia rentals, that you are taking this and looking at it with the screen share as I go along. Okay, so for the Residential Tenancies Act for Nova Scotia, some definitions. I'm just going to scroll through some of this, defining different things, what rent means, residential premises, small claims court. Calculations of time periods. Oh, that's interesting. Application of the act. Disposal of a property of tenant. Okay, here we go. A landlord shall not hold, or dispose of a tenant's personal property except in accordance with the order made pursuant of Section 17. Okay, so it looks like we're going to get into Section 17 about abandoned property left behind by a tenant because it's right there, which is good. Okay. Free access by tenant. Prohibition. Oh, you cannot have an application fee. No person shall deem, accept, or receive from an individual who may or apply to become a tenant of that person a sum of money or other value in consideration of or respecting the application by the individual to become a tenant. No application fee. Oh, okay. Requirement for lease. You must have a lease. I want to make sure that it's got to be a lease. Yeah, it's got to be a lease provided by the province. Looks like it is called something special. Standard form of lease in Nova Scotia is called a Form P. P is in Papa. And so that's the lease you got to use. All right. Okay. Oh, they're talking about electronic documents. Okay, so I'm on page 11 and it says electronic address. So where a tenant has provided in the lease an electronic address, so basically an email address, for the tenant to receive documents, the landlord shall provide in the lease an electronic address for the landlord to receive documents. Okay. So where the lease existing, so basically you're allowing to use email as a proper form of delivery and service. This is important because if you're going to do a rent increase notice or an eviction notice or a warning letter, something official, that's where it would go, is that email address. So they address that. That's good. Most locations have some kind of ruling about this, but sometimes they're not specific at all. In Nova Scotia, they say specifically that you can have an email, which is great. This is talking about the lease again, the Form P, explaining what it is, guarantee agreement, form of guarantee agreement. Okay. I'm just looking through this. Oh, here we go. Notice of rental increase. This is on page 15, section 8H, where there's an increase in the rent payable and the guarantor is responsible for the new term of the lease to which the rental increase will apply. The landlord shall provide written notice of the rental increase to the guarantor by a method of service. Yep, provided in section 8D. So that's what it was before. Service of documents. There it is. Bingo. Okay. So it talks about everything that the rent increase must have and how to provide that. Changes to the landlord rules, or if a landlord establishes a new rule, then you've got to submit this to the tenant, and it says you must give them at least 4 months notice prior to changing or having new rules in effect. Yeah, you can't just say here, this is in effect for tomorrow. That doesn't work like that. At least not in Nova Scotia. Most places it's not like that either. Okay, this one, I'm just looking for things that are on the bingo card. And let's just keep scrolling down here. Now, remember, I have six hyperlinks in the show notes. So I'm only on the very first one. So I might just keep going. We'll see, because as we go through, there's going to be some more items here. We haven't seen anything about security deposit or emergency contacts, late fee amounts, things like that. We haven't quite gotten that far yet. Notice to quit, renewal termination for sale of residential complex. Okay. Early termination for demolition repairs or renovations. This is a hot topic. I'm going to leave this one here. This is not normally something that landlords do, but if this applies to you, make sure you know this section, but make sure this is clear. Early termination of a year-to-year lease. So if basically you're in a year lease and somebody early terminates, a tenant in a year-to-year tenancy receives notice of a rent increase. The tenant may terminate the tenancy by giving landlord notice to quit. So basically, and they say 3 months before the effective date of the rent increase. So if you're going to increase rent on your tenant in Nova Scotia, and they come back and say no, thank you, and they'll just quit and they'll leave, which is fine. That's part of their they have that choice. That's fine. Okay. Early termination for income reduction. So if there's an issue with the person's ability to pay, typically there's a lot of medical stuff in here. And then there's another one, early termination for health reasons. This is on page 30, that says that where a tenant or a family member residing in the same residential premises in a year-to-year fixed-term tenancy has suffered a significant deterioration in health, that in the opinion of a medical practitioner results in the inability of the tenant to continue the lease, or where the residential premises are rendered inaccessible to the tenant may terminate the tenancy. And so they explain how they do that. This is pretty typical. You want to be a good human here, especially this is going to be more and more common as we go through with just en masse baby boomers, the shift in wealth. A lot of boomers are downsizing. They don't necessarily want to cut their grass. They don't necessarily want to take care of a huge house that they raise their family in. A lot of people are either selling or they're actually moving into rental situations. And so landlords like you and me are going to have to start taking care of more aging tenants. And so I'm actually bringing guests on in the future about this very topic, about tenants aging in place and ultimately passing away either in the unit or outside of the unit if they are in a hospital or in a care facility. So please note that this is not something that's going to go away anytime soon as early termination for health reasons. And here's another one, early termination upon acceptance into a home. This is a nursing home, a care facility. Yeah. Then you've got your safety issues as well. Early termination for domestic violence reasons. These are safety issues. Request for a new lease. So it looks like you do have a holdover situation. It looks like leases do end abruptly in Nova Scotia. Dean lease, fixed term lease, security deposit. Here we go. Where the landlord and the tenant have entered into a new lease. So this is talking about a new lease. The tenant must provide a new security deposit that complies. Okay, well, we haven't talked about the initial security deposit just yet. That's the new one. Okay, we're getting to this. Okay, this is rent increase. A landlord shall not increase the rent to a tenant for the 12-month period following the commencement of a week-to-week, month-to-month, or year-to-year or fixed-term lease. Where a landlord intends to increase rent payable after the first 12-month period, the landlord shall give the tenant a notice in writing stating the amount and effective date of the rent increase. In the case of year to year, it must be 4 months prior to the effective date. Wow. Month to month must be 4 months, and week to week must be at least 8 weeks prior to the effective date. And in no case shall the landlord increase the rent to a tenant more than once in a 12-month period without proper notice. Now, it doesn't say how long or how much they can increase the rent. Oh, here we go. Annual allowable rent increase amount. Landlord, land lease, community. Okay. Um, yeah, it doesn't talk about how much it could be. This one was about basically like a mobile home park, but that doesn't apply for here. Yeah, annual allowable greater than the annual allowable increase. Security deposit. Okay, so let's talk about security deposit and then we'll go on. What's the amount? Where a landlord obtains from a tenant any sum of money or other value that is in addition to rent payable, that will be deemed a security deposit. And the security deposit is one half of the rent per month. That's the security deposit. And you must pay interest. Okay, got it. And then you've got to return the security deposit together with interest, must be returned in 10 days. Wow, that's fast. Hmm. And you've got to make sure where landlord seeks to apply all or part of the security deposit and interest to outstanding rent or expense incur with respect to any damage, then you've got to All right, I am still screen sharing here, Nova Scotia. And I'm curious when landlords in Nova Scotia submit a rental increase notice, how much is a rental increase in Nova Scotia in 2026? Hmm. Okay. So this is saying, no, what's the source? It says starting January 2026, rental increases in Nova Scotia are capped at 5% per year, continuing to December 31st, 2027. Now let's make sure we are clear on where it's going. So this is novascotia.ca. In fact, let's click on that because I really try hard to make sure that this is based on someone that's not getting paid, right? That's why I typically don't like to promote law firms or national search engines or anything like that. So this is novascotia.ca. Rent increases, rent amount for subletting. Here it is. Interim residential rent cap, rental increase cap. Rent cap remains in place until the end of 2027. Rent can only increase up to 5% per year. And this was a change that was announced at the end of April 2025. So there you go. That's your answer for the amount that a rent increase can be, which is interesting. Okay. This is talking about servicing of documents. I may just skip to the next hyperlink. Yeah, so this gets into small claims court appealing evidence. Okay. Yeah, we'll just wait. Yeah. Okay, so this is novascotia.ca. Excuse me. So, forms for tenant. Now, I already mentioned this before. Landlord and tenant consent for email. Let's collect on this. New lease agreements, existing lease agreements, and who can use this form. Now, this is downloadable, so let's go ahead and open this up. Oh, this is cool. Landlord and tenant consent for email. And this is for, electronic addresses for the landlord and then electronic address for the tenant. So it's from the tenant. Oh no, tenants agree to provide the following electronic addresses. Okay, so if you have up to three email addresses, maybe not three tenants, but three email addresses and then an address for the landlord. This looks like it's an additional form for the lease, and then it says how to serve. This is cool. Sign and date two copies of the appendix. There it is. It's in an appendix to the lease agreement, and each party gets an original. Easy peasy. Okay, and then let's take a look at the lease agreement as well. I hear this Form P is pretty skookum. Before you start, you've got to have some info on what the tenant info is, rental unit info, what's included, and then you can fill out this lease. So, oh my goodness, 17 pages. Wow. But this includes the instructions as well. So make sure you are up on this. And this includes, wow, goodness sakes, I'm actually including this. This is the lease, but I'm including this in the show notes. This is actually very impressive. So we are doing that for sure. Okay, so inspections. This is a condition inspection at move-in, rentals in arrears. So it looks like 3 days late is we'll call the 3 days a grace period. And we haven't seen anything about a late fee yet. Oh, and these are fillable. Boy, that's convenient. Well done, Nova Scotia. Landlord, occupants. So these are adults or children. And typically I will also put pets. Believe it or not, I will put pets in here so that everybody knows if a pet is authorized or not. And that way, if an unauthorized pet is brought in, then it's not in the lease, right? So on this is talking about email address for service. Okay, how to serve, periodic lease, rent amount, rent increases, rental incentives. Sometimes we've seen this in other provinces as well, is that there's a rental incentive that if they pay like on the 28th, they pay ahead of time, then there's like a 1 or a 2%. Typically 2% is what I've seen reduction. So it's maybe, just a few bucks, but it's enough to allow tenants to pay in advance just to get a few dollars off their rent. That's kind of interesting. So it's sort of the opposite of a late fee because they're asking to pay in advance, giving an incentive to pay in advance. I've never personally used this. If you have, please comment or contact me. I'd like to talk to you more about it. It's kind of interesting. Security deposit not to exceed a half month's rent, and it will be deposited for the tenant by the landlord at boop, 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 and you have to put the financial institution and the branch. Tenant's notice to quit, general, okay, da, da, da. Statutory conditions. Okay, good behavior, abandonment and termination. Okay, well, this is the applicable. Abandonment and termination. If the tenant abandons the premises or terminates the tenancy otherwise than the manner permitted, the landlord shall mitigate any damages that may be caused by abandonment or termination to the extent that a party to the contract is required by law. Okay, so this is talking about entry, late payment penalty. It's in the lease, but it doesn't tell you the max amount of it. Okay, so that's your 17 pages for the Form P. That's actually pretty cool. Well done. Okay, I'm going to go back because this is the residential tenancy guides in Nova Scotia for renting. So this is a deeper dive. Now, this is usually the user-friendly guide. There's usually the law, which is the first one that we saw, and you'll see other locations like that where it's very legal because it is a law. And then you have like the user guide, which is what this is. And here is the guide for renting. And I think I already have this one open. Renting guide. Yeah, I do. Okay. So this is 8 pages. So this is probably going to be very streamlined, which is fine. So there's more forms. In fact, let's look at the forms real quick and then we'll go back to the guide. Okay, so, oh, this is the one we already looked at. Okay, so rental guides, renting, consent for email, rental condition report. Let's have a quick boo at that. Rental condition report. And this is probably, if I had to guess, yeah, it's sort of like a matrix. Move in, move out condition. So move in is in one column, move out is in another column. It's the location of the living rooms, stairway, hall room, bathroom, hallway, exterior basement, the list of repairs on initial occupancy, typically the amount of keys that were given, and then everybody signs. So the landlord signature, the tenant signature, or their agent. And yeah, okay, cool. It's about what you'd expect from a condition inspection form. That's okay. And these are both the same, which is kind of weird. Forms for landlords, forms for tenants. It's going to be the same, but okay. Application process, no fee, application fee. Tenants insurance, interesting. We don't normally see this, but this is in my bingo card for sure. Um, Contents of a rented house or apartment are important, are valuable, and all renters should consider protecting those items with insurance. If not, if there's a loss, tenants could lose everything in the event of theft or damage. Landlords may request that tenants have insurance to cover their personal belongings and personal damage by including it in the landlord rules. Renter or tenant insurance usually covers personal property such as furniture, clothing, sporting equipment, sound systems, musical instruments, cameras, computers, etc. But it can also cover a tenant's legal liability if they accidentally cause damage to the rental unit, for example, by fire, explosion, or smoke. All these things will depend on the insurance plan. For more information and rates, speak with an insurance agent or broker or visit Insurance Bureau of Canada's website, ibc.ca. That's the first time I've seen that in a long time that you've got tenants insurance in there. We basically say something very similar where we say, you know what? If we have a loss, we will get our building back, but you may not get your stuff back. And things, simple things that most people don't think about, like clothes, silverware, pots and pans, I mean, towels, all that is not cheap. It's not, you have to buy it if there's a loss. And so I think the minimum policy is somewhere around 100,000, at least in the States, it's 100,000. It may be less for Canada, but still 100,000, it sounds like a lot, but when you start adding, okay, so signing a lease, security deposit is a half month's rent. Landlord needs to put the security deposit in a trust account. The trust account stays with the property and not with the landlord. That's right, because it's the tenant's money. And moving in, rent. We talked about rent increases already. Maintenance. Okay, here we go. Tenants need to keep the rental unit and all appliances clean. They are responsible for any repairs that need to be made due to neglect or damage on their part or by any guests they allow into the premises. Tenants aren't allowed to interfere with the landlord or other tenants' ability to safely occupy the premises. Landlords need to keep the rental property fit for living and comply with any law respecting standards of health, safety, or housing. This includes making any repairs that are not due to the tenant's negligence. Landlords must not interfere with the tenant's ability to safely occupy the premises. Heat and utilities. This is interesting. Landlords aren't allowed to turn off the heat in a unit, even if the tenants owe them or there is a dispute. If the tenants are responsible for heating the unit, tenants need to keep it warm enough to prevent damage. The temperature on the premises should be between 20 and 22 C. Landlords aren't allowed to disconnect other utilities like electricity, water, cable that are included in the lease. Yep, that's pretty much standard. Makes sense to me. Okay. Can't change the locks. Subletting, ending a tenancy if there is a problem. Okay. Very simple user guide. All right, let's keep going. I'm still screen sharing, so if you're watching at YouTube, at My Life as a Landlord, you'll see my screen share. There's Form P. There it is, renting guide. Accounting for the sale of tenants' abandoned personal property. This is Form B. B is in boy. And so let's say you've got a tenant who has abandoned the premises for whatever reason, whether they were sometimes they're thrown in prison, sometimes maybe the tenant sadly passed away in a car accident. Life happens. This is what happens. Maybe they just were unsafe and or feeling unsafe and they just left and they abandoned their goods. So this is the form that you would use accounting for the sale of abandoned personal property to calculate the proceeds from selling your tenant's abandoned property at the end of the lease or tenancy and inventory the goods sold. Okay, so typically in an abandoned property situation, there is usually a timeline that the landlord has to either hold the items or put them in storage and hold the items the whole time they're trying to notify the tenant that they have their stuff. So the timeline is what we're looking for. And then there is typically also a dollar amount. The dollar amount is a bit of a threshold. Below that dollar amount means that the landlord typically can throw it away, that it's basically worthless. There's some kind of dollar amount, but above it, they have to inventory or whatever. So we're looking for two things. We're looking for a timeline and a dollar amount. And for Nova Scotia, we have it. If a tenant leaves personal property behind after a lease has ended, the landlord can sell or dispose of this property after receiving permission from the residential tenancies program after it's been held in storage for 30 days without being claimed by the tenants. Now let's think about this here. So you have a tenant who has abandoned a unit with stuff in it, couches and clothes and whatever, stuff is in it. You are just trying to figure out, you may not have even known that it's abandoned until maybe there's a non-payment of rent. Something is going on. The neighbors are saying they haven't seen people, they're not coming or going, they're just gone. So as a landlord, you're going, okay, what am I going to do with this stuff? Let's just say you go to the property and you knock on the door, there's no answer, you go in. Or let's just make it easy, you go in. So you deem it abandoned, but you also have to make sure with the residential tenancies program, is it actually abandoned, right? There is a protocol to some of this stuff, right? So you need to be careful on the whole possession of the unit part. But let's just say it's been deemed abandoned, you have the possession, but now you also have the tenant's stuff. So then what you've got to do is now arrange for movers to move it into some kind of storage. Now, it could be storage in the garage, in some kind of a garage. Because remember, what you're trying to do is you're trying to get the unit back up to speed to rentable and habitable condition, market it, and get a new tenant in there so that you can continue making revenue. Because the whole time the unit's been abandoned, no one is actually paying for that unit, right? So that's what you're thinking. But now you've got to inventory the items, you've got to move stuff, you've got to apply to residential tenancies program potentially, because it says after receiving permission from the residential tenancies program, after it's been held in storage for 30 days without being claimed by the tenants. Okay. You need to sell the goods if they're worth more than $500. So if you've got a big TV, or maybe a big couch or a gaming desk or like something that's more than $500. If they're worth less than $500, you can choose to sell them or dispose of them in other ways. The goods have to be sold publicly if the goods are worth more than $50. So you've got to sell them on Craigslist, you've got to do a garage sale, you've got to, advertise in the paper, put it on Facebook Marketplace. You've got to do something public, and then you've got to make sure you're keeping records of this. Take pictures saying, I sold these things publicly. Okay. You will need to submit the Form B within 10 days of selling your tenant's abandoned property. And so it explains all this. It should take 2 to 3 months to complete the process. It can take longer if the information hasn't been filled out correctly. And of course, the first thing they say is do a Form A, which is the inventory of the person's abandoned property. So here is how you do it before you start. Basically, I bet this is a big grid, right? And they tell you how to fill it out. It's 4 pages, how to fill it out. And then this is the grid. Name of tenant, landlord, what's going on, list of abandoned property, additional information. Now you might list the abandoned personal property in full, and if I was you, I would put an approximate value of it. So here it says, status of personal property, the goods are unsanitary or safe to store, dispose of immediately. Like if they let their fridge go, that definitely would be part of it. The goods are an estimated value under $500. The landlord requests permission to dispose of them after storing for 30 days. Or it's over $500, landlord will store them for 30 days. Goods include abandoned mobile home. So you have to then deal with a mobile home. That's fun. Okay, well, that's how you do it. You do an inventory of the property, you hold it for 30 days, and then if it's worth more than $500, you have to offer them for sale publicly. Okay, that's what you do. And there's the Form A. Okay, so now I was looking on how to help landlords in Nova Scotia get help. And so I Googled just simple landlord help Nova Scotia, and up pops this Facebook group. So if you are a Nova Scotia landlord, make sure you are subscribing and following Landlords Nova Scotia. And I'm sure there are others, but this is another forum that you could do, that you could get in. And so it looks like you've got locations, you've got apartments for rent. It's discussions of different ones, insurances, like there's, yeah, power outages. This is, it's kind of cool. Anyway, so there's 10,000 followers. That's kind of cool. So make sure you're in there. Also, you could go to Nova Scotia Legal Aid. So that's nslegalaid.ca. This, of course, is a hyperlink also in the show notes. And then you can find a legal aid office. Let's see if we do that, how many there are in Nova Scotia. Looks like executive office in Halifax, Amherst, Annapolis Royal. Oh, there's quite a few locations. My goodness. Wow. There's several offices. My goodness. And they all have phone numbers. So if you are needing some kind of legal aid, let's go to apply online. Let's just see what it says. So this tells you standard application suitable for most applicants applying for criminal, family, or civil matters. A civil matter may be the security deposit part, or if you have damage, but you might call them. Like that might be something, just call them and say, hey, I'm a landlord in Nova Scotia. I've got this problem. What do I do? And they will likely help you with what to do. And you could probably even walk in your local legal aid society office, right? Okay, did I get them all? I think that's it. Now, for the novascotia.ca, typically, if you go to contact us, in fact, let me expand this because they will have a number of, yeah, so here's rental scams, security deposit claim, rent evictions fact sheet, and then privacy terms. I was looking for like a contact us, but I'm not seeing it. Let's go back out to the main. Yeah, here it is, contact us. So you just go to novascotia.ca. There's all kinds, department directories. But you can just call their main, like if all else fails and you don't know what to do, you can just call their main number, which is here, 1-800-670-4357. Or you can go to Access Nova Scotia, your local Access Nova Scotia location. Okay, I'm going to stop screen sharing and then we're going to go through the bingo card. And here we go. So we actually found quite a bit on this. But let's go through the bingo card here. So it's an overview for Nova Scotia Residential Tenancy Act, recent provincial guidance. But again, you've got to confirm details with your official residential tenancies program or a local real estate lawyer in Nova Scotia before relying on this because I'm just going through what I have found, which may not be exactly correct, especially things can and do change as you go. But let's start with a tenant application fee. In Nova Scotia, landlords are not allowed to charge a application fee. I'm going to write that down actually. No application fee, which I've not seen in a long time, but that's okay. Grace period for late rent. The law does not set a grace period, but rent is due on the date of the lease. But it's saying we did see a couple locations where you can apply for non-payment of rent demand at day 3. Late fee amount. We didn't see a late fee amount. In fact, let me go back in here and just go Nova Scotia late fee. Late fee amount. And this is saying generally a fixed amount. I've seen a couple different ones. Fee and allowances. Here we go. Fee and allowances under the Residential Tenancies Act. Oh my goodness. Oh, this is just court fees. Oh, that's not helpful. Okay. Yeah, tenantrate.ca. No. So we didn't officially see anything that is a late fee in Nova Scotia, but we saw most things actually. I'm getting back that it's 1% of the monthly rent, that it cannot exceed 1% of the monthly rent. So if you're charging someone $1,000 a month, 1% of that would be $10. So that would be, but I have no way to confirm that. So at this point, late fee is still a question mark. Don't know. Security deposit, landlords can charge up to 1/2 month's rent as security deposit and no more, separate from rent and cannot be demanded as last month's rent. Further, the security deposit has to be held in a separate trust account by the landlord and not commingled with general funds. Also, as a landlord, you have to declare what bank or credit union and the branch of where their money is. That's important. Lease wording and details. I actually put the standard form of lease for Nova Scotia. That's the form P as in Papa in the show notes. So if you want to see that, please go and check it out. It's actually very detailed. It's quite impressive. You know, there's a lot of locations that don't give you leases. They just sort of throw you out there, but Nova Scotia doesn't do that. That's good. Any additional rules in addition to the lease must be reasonable and consistent with the Residential Tenancies Act and regulations. Illegal terms, for example, extra deposits, waiving statutory rights, are unenforceable, and shame on you if you do that. Don't do that. Emergency contact in the event of abandonment, incapacitation, death, or imprisonment. The standard lease does not generally require an emergency contact in Nova Scotia, but landlords often request this as part of their application or lease documents as a practical measure. It's policy driven. So, as best practices, make sure you have an emergency point of contact, and ideally that whoever you have on file is a next of kin. That would be ideal, especially as our population ages. We just discussed that earlier. Let's talk about pet and animals, pet deposit, pet rent. Landlords cannot ask for extra deposits, including pet deposits, beyond the allowed security deposit, which is a maximum half 1 month's rent. Although we didn't see anything regarding pets at all during our review here. The Act, however, does not explicitly regulate pet rent as a surcharge, but any charge must still comply with the overall rent rules and not be disguised as an unlawful extra deposit. Some tenant advocates treat ongoing pet rent with caution. Okay, fair enough. Does delivery of the signed lease, is it required? The standard lease must be provided to and signed by both parties, the landlord and the tenant must receive a copy. It does not have a day past the signing, though. It just says they have to receive a copy. So make sure you send it. Make sure you document that you sent it. These are all little details that all count. Condition inspection at move-in. The Act encourages documentation of the unit's condition, written move-in inspection report with photos, but make sure it's not just photos. It's the written checklist. In fact, Nova Scotia gives you a move-in checklist. We've actually seen it. It's great. And the photos are complementary to that. You have to have the checklist first. Standard warning letters or wording. The regulations prescribe official forms, for example, notices, rent increase application forms, but not generic warning letters. Landlords and tenants typically use their own letters while ensuring they meet content and notice requirements. So make sure if somebody is misbehaving that they smarten up. You have to write them in this case, you can write it by email if the tenant has allowed you to write it by email and just say, look, we're getting noise complaints or we're getting complaints of this. You're parking your car, you're blocking things, whatever it may be. Say, look, you have, X amount of days to correct, and it has to be a reasonable amount of time, right? Okay, required maintenance inspections. I didn't see any fixed maintenance inspections required for Nova Scotia, but we did talk about maintenance, which is cool. How often rent can be increased in Nova Scotia? Rent can be increased only once every 12 months and not within the first 12 months of a new tenancy type. Notice is required for the rent increase for a year to year or month to month. Tenancies, you've got to give at least 4 months notice and at least 8 weeks before a week to week rent increase. And for fixed term leases, if you're not doing year to year, if you're doing something else, you have to increase during the term, but it must be clearly set that you're going to do that in the original lease. You can't come back later. How much can you increase the rent? We talked about this already. We found it on the novascotia.ca website. Provincial rent cap applies until December 31st, 2027, limited to a maximum 5% per year starting January 1, 2026. And there are a couple of details with that. So if you're looking at rent increases, make sure you're doing your homework. Okay, renter's insurance. I am shocked that Nova Scotia has mentioned tenant insurance. It doesn't require it, but it strongly recommends it. That's important. How about landlord abuse of access defined? The Nova Scotia legislation regulates landlord entry for notice for non-emergency entry, but abuse of access per se is not specifically labeled defined term. Repeated improper and harassing entries can still be challenged under tenancy rules as under breaches of quiet enjoyment. Absolutely. Okay, landlord retaliation, both defining and timing. The Act does not contain a clearly labeled anti-retaliation section, but retaliatory conduct such as raising rent, decreasing services, or trying to evict because a tenant asserted legal rights may be considered improper and can be contested before the residential tenancies program. Timing is assessed case by case. Yeah, so you want to be careful on that. So it's not specifically defined. We didn't see it when we went through it. I didn't see it. End of a fixed lease. It looks like it is a fixed term lease. Acceleration clause for early termination. Clauses that attempt to accelerate all remaining rent immediately upon termination are in conflict to the Act. Cannot do it. Condition inspection at move out. Well, that's important, especially if you intend to deduct from the security deposit. So you must do move in and move out. Timing of security deposit, timing to return it. I believe it was quick. It was like 14 days. We saw that. And you must return it with interest. Use of deposit as last month's rent. No, cannot. Penalty for not returning the deposit. If the landlord fails to return the deposit or properly account for the deductions within the required time frame, tenant can seek an order for the deposit and potentially interest in addition. Non-compliance may lead to an enforceable order against the landlord. That's not fun. Notice of eviction for non-payment of rent and utilities. Looks like you can serve notice to vacate after 30 days of unpaid rent, giving the tenant an additional days to move out before proceeding. Unpaid tenant billed utilities that are a part of tenancy obligations can also support the application. Yep. Notice of eviction for mischief, damage, or serious breach. And looks like how long to obtain a possession of a unit. In Nova Scotia, they're reporting that it is 2 to 5 weeks to obtain an order and then to enforce it. And then abandoned items. There was a lot of information about abandoned items, about how to inventory them, what to do, 30-day storage threshold, and then above a $500 value, you have to sell them publicly. Yeah, each of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. What are the basics of that location's tenancy laws? What are the nuances of that location? What's some guidance about abandoned items left behind by a tenant and where to get help in that local province? As I did that, you saw me keep track on my bingo card of standard items that I see most often in tenancy laws in different location, which helps summarize for this location. This is the same format for every specific location-specific episode, so if you're interested in another geographic area in the library, you already know what I'm going to talk about, just in a different location. Keep in mind, by the end of 2026, I will have done all the Canadian provinces, all the US states, all of Australia, and I'm getting into Europe by the end of the year. Pretty cool, right? So that library is going to be chocked full of locations. But please remember, this episode and none of my episodes are all inclusive. You must research further in your own specific area where your rentals are located, in this case, Nova Scotia or beyond. But today's episode will get you started. Now, here's your call to action. If you are listening to this podcast, chances are that you're either new to real estate or you have real estate in Nova Scotia. Things you can do to help yourself is read the Nova Scotia Residential Tenancy Act and become familiar with all of the forms. And 2, get in the room with other Nova Scotia landlords, either physically or electronically. Physically, you can do meetups. There may be meetup groups of other landlords all across Nova Scotia, Halifax, and other places. So make sure you're checking that out. Jump on Facebook. There's a Facebook group there. That's where you would meet other landlords in Nova Scotia electronically, but there are other locations as well. There may also be associations in Nova Scotia for landlords that you can join for yourself. And again, get in the room with other Nova Scotia landlords who've learned lessons and they can help you with your questions and concerns. I hope you enjoyed today's show all about Nova Scotia. Don't forget to subscribe for more expert advice and real stories from across the rental property world. I'm recording this episode today from San Antonio, Texas. Why? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 222 about the great state of Indiana. I'll see you there.